Good afternoon. Welcome back. Well, earlier this week, the Constitutional Court ruled the decision by the Gauteng provincial government to dissolve the Tshwane Council last year when it failed to elect a mayor was unlawful. It was a split decision. The majority of judges ruled that the Gauteng provincial government was wrong to dissolve the council. The DA challenged the decision, saying it was only because ANC and EFF councillors refused to attend council meetings that it could not actually elect a mayor to the council. The DA had said that this decision shows the Gauteng provincial government, which of course is led by the ANC, was wrong. Advocate Quinto Kuhn is the head of legal services for the Gauteng Department of Cooperative Governance. Mr. Kuhn, good afternoon to you. You've issued a statement saying people should pay a lot of attention to the minority judgment, which agreed with you, rather than the majority judgment, which ruled against you. It is the majority judgment, of course, that stands. Why do you believe the minority judgment is so important in this?
Thank you, Stephen, and once again, good afternoon to you and your viewers. I think it's the whole judgment is very important for us, and not only for us, but rightly so for the rest of the other provincial governments in the country, because we're dealing with an important issue in terms of Section 139, and as you correctly point out, pertaining to the dissolution of a municipal council, which is a serious action that can be taken by a provincial government. And there was always this issue of divergent views on the interpretation and application of that particular Section 139 of the Constitution. Hence, our primary objective, why there was a direct appeal launched with the Constitutional Court, because the Constitutional Court is the highest court in the land, has never had the opportunity to deal with this particular section in order to provide clarity. So we thought it was an opportune time in terms of the dissolution of Tshwane, that the Constitutional Court is the highest court in the land, the apex court, to provide clarity on the important question of the interpretation and the application of this judgment. And as you now know, the judgment that was delivered, in fact, what we want to clarify, there were three judgments. Yes, the main judgment, the first judgment, is deemed to be the majority judgment. And they set out their reasons why they found that the appeal should be dismissed and the dissolution of Tshwane was unlawful. Equally so, the two other judgments by the Honorable Justice Jafta and the Chief Justice Mogoeng raises also important issues insofar as it relates to the correct interpretation and application of the Section 139 intervention. So in that respect, all what we are saying, first and foremost, we welcome the judgment. We are relieved that the judgment is finally out, because most importantly, the judgment now provides clarity in terms of what is expected from provincial governments and the executive councils in the province. But also important, Stephen, it's not only important for us, it's also important for municipal councils to read this judgment in its totality and also understand how they should relate in respect of the provincial government.
Well, sure. I mean, Mr. Kuhn, the context of all of this, as you well know, is we're about to have local government elections. It seems, I think, fairly likely that there will be hung councils, in other words, no majority in several councils, but some of them in Gauteng, in fact, and so that this issue is going to come up again and again. Just for the record, you are going to comply with the majority view, right? The MEC said that you are obviously going to do what the Constitutional Court has ordered.
Well, of course, it's not like we have a choice, Stephen. It's the apex court. It's the highest court that has made the determination. We respect the judgment. As we say, we welcome the judgment. We have studied it studiously. We know exactly henceforth what is required in terms of our powers. So therefore, exactly, we will definitely follow the court's ruling.
I mean, the whole level of contestation, the political heat around this, and some of the legal heat, is that it's because it's the ANC that governs Gauteng. It was the DA that had governed Tshwane up until this moment. And that's where the heat comes. It's different parties. Now, I mean, as an example, the MEC has said, and I think your department has said, that the reason it was important to take Tshwane into administration was to ensure that the council provided proper services to citizens, and it was failing to do that. But, I mean, in the Eastern Cape, the same party, the ANC, governs a place called Makanda, I'm sure you know of it, where a High Court has ruled that the services are not being properly rendered by the council. The council has failed to render those services, and so the province should take it into administration. And the province, which there is led by the ANC, is helping to appeal that judgment. You can see where the political heat comes in these cases.
Yeah, no, I can fully understand, Stephen. I'm alive to that fact. And perhaps, as I indicated in our last interview, I'm not a politician, but nevertheless, we are alive of those dynamics that can be at play. But where we are sitting, we must remember, is that the Constitution obligates all spheres of government to provide services to communities. And whenever, in terms of what is termed they have executive obligations in terms of the Constitution and other related legislation to do so. And in circumstances where it arises that they fail to do, then the Constitution demands certain actions that must be taken by the provincial governments. And now, as I say, the reason why we welcome the judgment for the clarity it provides, it tells us exactly going forward what is required to do, that we must do from our side. Of course, the important issue, if you have read the judgment, it spends a great deal of time setting out the constitutional framework in terms of cooperative governance, and how the different spheres of government should cooperate with one another. And we take patent heed of that legal framework that has been set out in the judgment. So far as the political dynamics, I suppose that will always be there, but as I say, we will be guided by the Constitution, and this judgment has provided clarity in respect of that, and we will follow it to the letter.
So, I mean, this is where it starts to get important, is that after the elections, as I say, when this contestation comes, and it's likely that the ANC might try and form a coalition, let's just say, in Joburg. It's likely the DA might try to form a coalition in Joburg. The province is going to be a neutral player. You can give us that assurance. It will be guided by this judgment. That's why this judgment is so important.
Yes. Yeah, first and foremost, in our statement today, we first started to say that we underscore that the provincial government, we respect the Constitution, and we, as the supreme law of the land, we embrace the principles of the separation of powers. We also recognize and appreciate the important role that the judiciary as the custodian of the rule of law. But we must also note that, especially in terms of the Constitution, in terms of Section 154, the province has a constitutional responsibility to monitor municipalities and, again, in line with what the judgment is setting out, to support municipalities in respect. So we will not shy away from that responsibilities or abdicate it in any way. So we will monitor, we will support. Intervention really now is a last step, is a last resort when all else has failed. And that's in terms of the first judgment, termed the majority judgment. But equally so, the second and the third judgment say, when you are faced with a certain, when the certain circumstances or conditions in Australia are such that you have no option but to go straight to an intervention. So the circumstances that will prevail at a particular point in time will determine the type of action that is required.
Advocate Quinto Kuhn, Head of Legal Services for the Gauteng Department of Cooperative Governance. I do appreciate the time. Thank you. Series of judgments to go and do our homework and have a look through.